Welcome to Partnerships for Profit, the podcast where we bring you inside the world of joint ventures, strategic partnerships, and powerful collaborations. Whether you're looking to expand your network, find new referral partners, or scale your business, you're in the right place. Let's get started.
Welcome back to another great episode of Partnership for Profits. We have an awesome guest here today, someone who is local to Louisiana, which is our backyard where we're based. We have a guest here who you want on your side if you are running a business. We have Megan Kelley, who is a top-rated civil litigation attorney and a Super Lawyers Rising star. She's known for helping founders and business owners avoid costly mistakes and for getting tough cases across the finish line. You work with entrepreneurs at every stage, and you work with employees and employers. I just found that out in our little conversation ahead of time. She's also a wife and a mom of three, and she's someone who believes legal strategy should be practical, preventative, and clear. Megan, welcome to Partnership for Profits. I'm super glad to have you on the show.
Thank you. I'm very excited. Thanks for having me.
Yeah, I'm happy to be your first podcast experience. So hopefully this is a good one for you.
Yes.
But getting started, tell me a little bit about your practice and about your firm. Kind of let us know what you guys focus on and what you guys do.
Yeah. So I am an associate at Business Law Group based out of New Orleans, and we are a general business law firm. So we offer a variety of services. We serve as a fractional general counsel to a lot of businesses, big and small. We do everything from trademarks, corporate compliance, operating agreements, HR issues, to the employee side. We also review employment agreements, negotiate them, and do some plaintiffs' employment law litigation as well.
So is that the area of law you've always practiced in, or did you start somewhere else?
I started generally on the civil side doing, I was at a firm in Baton Rouge right out of law school. That's where I had a clerkship my 3L year, and they hired me immediately out of law school. And we did a lot of banking litigation. So for financial institutions, financial fraud, and general civil stuff and business law. And then when I had my oldest son, he's 7. When I had him, I moved back home to Ponchatoula. That's where I live now. And was doing plaintiff's personal injury law. And I did enjoy the plaintiff side of it, not so much the personal injury side. I much preferred the business side of things. And so I was freelancing for a while for civil law firms, allowing me to spend more time with him while he was a baby. And then I started doing some freelance work for Amanda at Business Law Group. And over the years, it turned into this associate relationship. And I've been here 2 years now, and I absolutely love it.
That's awesome. Love that. So talk to me a little bit about what drew you to business, to working on the business side of things. So what is it about that side of things that kind of drew you there, specifically working with business owners, entrepreneurs, and also on the employee side of things as well? What was the draw for you to go into that?
Well, it's very interesting because every day is different. One day I may be registering a trademark for a new business. One day I may be looking at a lease for a business who's going to be renting a commercial space. And then another day, a plaintiff may call me who thinks they've been terminated on a discriminatory basis, and I'll bring a lawsuit for them. And so doing the same thing every day can kind of get a little mundane. This stays interesting, it stays exciting, and I'm still learning new things every day. And I've always loved school, and so to continue to learn today makes my job more fun.
Well, I guess that has to be a big part of what you're doing, because that kind of stuff changes all the time too, right?
Yeah.
As far as regulations and laws and all, that stuff's constantly changing. So I guess you have to stay on top of things and educate yourself constantly.
You do.
Yeah. So I was reading your bio, and I think one of the things you said is that there's a lot of new business founders who skip a legal step that ends up costing them like thousands of dollars later. Can you talk a little bit about what that legal step is and how they can fix it?
Yeah. So a lot of new businesses that we encounter are relying on verbal relationships. they're excited, they have a new business idea, they're ready to go, and it's either with a best friend or a spouse, or they're starting it themselves with just one employee, and they don't have any written agreements, no operating agreement, no employment agreement. And that's all fine when things are really exciting and new in the beginning, but it can go downhill fast whenever you have a disagreement about something. And so from the moment we sign a new client, I ask them, do you have an operating agreement? And let me see it if you do. A lot of times businesses that do have an operating agreement haven't gotten it drafted by a lawyer. They've just gone online, Google search, pulled something up, and it's arguably better than nothing, but a lot of situations can come up that they haven't thought about that aren't in their operating agreement. So we'll either amend it, draft them a whole new one, or if they have employees or they consider themselves to be an employee of the business, we'll draft them an employment agreement as well. And it saves them down the road. If there's a dispute, we know exactly what's going to happen. There's a procedure to follow, and they are avoiding all of the litigation that would normally happen if it's not written down.
How often do you see that happening where they're not writing this stuff down? Like, you talk about like verbal or handshake agreements. They're pretty common.
They're very common, especially down here in Louisiana. We're not like a very litigation friendly state. There's this stigma around hiring a lawyer, and that's in all areas, personal injury to business. And so most people, when they start a new business, they just think, I need to go to the Secretary of State. I need to form my LLC, open my doors, and I'm good for business. And they don't think about the legal ramifications if nothing's written down.
Okay. Cool. Good to know. When you're starting a business, it pays to call an attorney and get it done the right way from the jump. That's crazy that so many people are willing to do verbal and handshake agreements. Like, you got to have it written down. To me, that's common sense, but I guess it's not to everybody.
No, and even if they have something written down, a lot of people don't think about like the day-to-day management and what needs to be written down about that. And so say you're going into business with your best friend or your spouse, and you each have one vote on things. What happens if you don't agree?
Or if you get divorced,
deadlock, or if you get divorced. Exactly. What is the procedure going to be? And we've, written down everything from flipping a coin for the deciding factor to, selecting a neutral third person to come in and make the decision. But if there's no procedure for that, then you're just stuck in this limbo of disagreement, or in the case of a divorce, fighting with your ex over their business interest, and it can get really messy.
Yeah. I guess they just don't think about those things. There's something that I saw that you guys do. You offer, is it $100 a year corporate compliance add-on? That's like, for most business owners, that sounds almost too simple, right? But why does something so small like that, why would that make such a huge difference in maybe in a case like you're just talking about, where there might be a dispute about, the agreements that are set in place? What does that corporate compliance add-on do for a business owner?
Yeah, this is a service we add on for all of our, general counsel clients. And it just takes the headache away from some of these tasks that they have to do. So it keeps them in good standing with the Secretary of State. It keeps those corporate formalities in place. Like, we're going to make sure they have an annual meeting. We're going to make sure minutes are taken of that meeting. If there's any kind of action, we're going to make sure there's a resolution. And that's important later in case the business is sued. Those corporate formalities are important to protect the individual business owners from having any kind of personal liability. And that is the main thing we want to avoid in terms of risk.
It's such a small fee for such a huge thing to get taken care of. Very cool that you guys offer that. So can we talk a little bit about demand letters?
Sure.
As a business owner, I think that's something that every business owner dreads, is like if you get that demand letter in your inbox. So if you get one of those as a business owner, what is the first 24 hours supposed to look like after you get one of those, and what should you not do if you get a demand letter?
Sure. I've been on both sides of the demand letters, receiving
Yeah.
and writing. And on the receiving side, business owners, the number one thing you should not do is immediately respond in the heat of the moment yourself. Small business owners have, such high emotions. They're so personally invested in these relationships, and they may spout off in a fit of rage. And it's like criminal law. Anything you say can be used against you later. And so I always say, don't respond, don't email back, don't call them on the phone, especially. Don't text them. Send it to me. We'll respond on your behalf.
So you get a demand letter, the first thing you need to do is contact your attorney and say,
Contact
hey,
your attorney,
look
number
at this
one.
thing. What do we need to do? Okay, interesting. Very cool. So contracts, you've seen what makes contracts bulletproof and what leaves them wide open. So what are some clauses that every business contract should have that can prevent the most common disputes in a business
And
agreement?
in employment agreements specifically, you need three main things. First, you want to make sure it's at will. You don't want to give the employee any kind of expectation that this is for a specific amount of time or they can only be fired for cause. You want it to make very clear that it's employment at will. Second, you want to protect your confidentiality. And so you want to have a confidentiality clause and some sort of restrictive covenants, whether that's a non-competition clause or non-solicitation. So these employees are going to come in and they're going to learn all about your business practices, your client lists, your marketing strategies, and you want them to protect that proprietary information both while they're employed and when they leave. So having that very clear in the employment agreement protects you and protects that proprietary information. And then you also don't want them to go learn all this from you and then start a competing business and take all your clients. So that non-solicitation protects you there so that they can't reach out to all your clients and say, hey, come jump ship with me. But it's really important, especially in Louisiana, we have such strict non-competition and non-solicitation rules to be enforceable that a lot of attorneys in other states may draft it and it not be compliant with Louisiana law, and then it's not enforceable at all. So we make sure that it complies with all of the requirements so that, they don't jump ship and steal all your clients and your business.
So let's reverse that for a second. And I want to talk about non-compete agreements on the employee side of things. Sometimes I've seen them in my experience in the past where, I get hired in a new job and you have a non-compete agreement that's part of the paperwork that comes in when you're filling out all the, filling out your tax forms, filling out all this stuff, you get a non-compete agreement. And some of them are pretty crazy. Like you can't work in this field for 7 years after you leave this job. In this field, like it's pretty broad. Like, oh, you're in marketing. Well, you can't work in marketing for another company for 7. Like, how ironclad are those? And how, as an employee, what kind of stuff should you be looking for? Should you just sign those things based off of what you're reading there? How do you protect yourself in that arena as an employee, not on the employer side, but on the employee side, when you're looking at a non-compete?
Yeah, I've looked at 2 really recently, one for a real estate agent and 2 for a nurse practitioner, both really competitive business areas. And they were being asked to sign a 2-year non-compete for the whole state of Louisiana. And so from an employee side, we want to narrow it down as much as we can. We understand that, the business doesn't want to train you, teach you everything, and then you leave and use it elsewhere. But also we want the employee to be able to make a living, especially a real estate agent and a nurse. They need to go out and do that skill elsewhere. So if we can negotiate it to a lower time period, that's a great place to start. Louisiana, the max is only 2 years.
Okay.
So it can only apply there.
2 years is still a really long time, though.
It's a long time. So then we try to narrow the territory. So for like the real estate agent, it was certain parishes, and we were trying to find locations where she could go outside of these parishes, which still is inconvenient because you may have to commute after, but at least you're able to work. We don't want you to not be able to do real estate for 2 years. That's just not feasible.
Yeah.
You also have to define the business. And so if it's too broad, that can be one way you can argue it's not enforceable. If you narrow it for like the nurse practitioners I looked at, we wanted to narrow it to family medicine so that she could go into a different area,
Okay.
dermatology, whatever, so that she wasn't directly competing with that business, but could still use her degree.
Okay. That's cool. So just I want to stick to the subject for just a minute. So
Yeah.
if you're a younger person, maybe you're just out of college and you're getting your first job in the corporate space, for example, and you've got that non-compete in front of you. I imagine, I mean, I didn't when I was younger. If I got one of those, I'm not thinking, oh, I need to take this to an attorney and have them look at it before I sign it. Because generally you're getting those after they've hired you, right? Like you've been hired on at this place, and then they're asking you to sign the non-compete. I mean, should everyone have that reviewed by an attorney? Like, how do you explain to your employer, like, yeah, you've given me this non-compete, I'm going to take this to an employment attorney and make sure that I'm covered? Like, what does that look like? Does that affect whether you're going to keep that job? Like, I don't know. I think for a younger person entering the workforce that sees that, at least I know from my experience when I was entering the workforce as a younger person, that was I wasn't thinking, I was like, cool, I got a job. That's kind of where my head was at. So
Most people feel like that, like I have to sign this or I don't get the job.
right.
And a lot of people aren't even comfortable negotiating it. Like, I'm not really supposed to go back to them and try to either get more money or lessen
Yeah.
these clauses. But you absolutely can. And most employment agreements have a clause where they recommend you bring it to an attorney to review it. And so once you get an offer letter, ask for a copy of the employment contract so you can look it over. You don't have to say, I'm bringing it to my attorney, but ask for the employment agreement, say you want to look it over, and do have an attorney review it so that they can say, this non-compete is really scary. I think we need to negotiate this. Or if you are going to sign this, you need to be paid more per hour because this is really stringent on you. And it can be scary. It's your livelihood on the line, but if things go sour, you need to be able to get another job and not be stuck with one of these really,
or
crazy
if you have another opportunity to go to move to work somewhere else that maybe is going to pay you more, or maybe I don't know. When you're younger, people move from job to job. Like they check new opportunities out. So how do we educate younger people that are entering the workforce about this and make sure they are paying attention to that stuff and that they aren't getting, kind of cornered in with a non-compete where, oh, I can't go sign on with another real estate agency and sell houses somewhere else. How do we, because I don't think that's something that's, I don't know. I don't feel like there's enough education on that end of things for younger people that are entering that area of the workforce. What are your thoughts on that? Do you think they are or no?
No, I don't think they are. I think the ones that have come to me, especially early in my career, were just my friends who knew I was a lawyer, and they would say, hey, look at this, but it was after they had already signed it. For newer, younger people entering the workforce, how can they learn about this? Podcasts like this one, different blogs. Business Law Group has the blog. We post a bunch of different topics that apply to both business owners and employees. And I think anytime you're going to sign something in writing that's a binding contract on you, whether it be an offer on a house or an employment agreement, you need to have an attorney at least look at it to see what you're obligating yourself on.
That makes perfect sense because when you are closing on a house, there's an attorney. Like you have to have an attorney involved, a real estate attorney involved when you are closing on a house. I just don't think people think about from the employee side, I need to have an attorney on my side before I start this, low level marketing job in this company that's hired me. I just don't think it's really in anyone's mind that, they need to, I guess, but yeah, lawyers are important, right?
Yeah, and there's like power balance issue. You feel like, oh, they're a big company. I'm just one little person. I'm just a cog in the machine. How do I, why should I hire an attorney to look at this when I can't go up against them? And that's when, it's really helpful to have a small boutique law firm like we are, because we appeal to both that small individual employee and the businesses, because we do represent both.
Okay. Yeah. Yep. You're right. I mean, the lesson here is attorneys serve a purpose. You guys exist for a reason, and the vast majority of you are here to help people, to make sure that things are done the right way and that you're covered. And I mean, I think that applies to every area of law. We work with attorneys all the time, so I'm very defensive of people who are like, I hate lawyers, and I'm like, you just don't know lawyers, and you really don't know what they do. I love hearing that you guys are working on both sides of the fence for that, and helping employees as well, which is great. Let's get back to the employer side of things for just a second. So as a business is growing, legal needs shift, right? So what's the biggest change in risk or exposure that a company can see when it goes from just being a startup to kind of scaling up? What is that? What are some of those things they need to look for?
Well, the more employees you add, the more legal claims start coming into play. Some of these bigger federal laws about like the FMLA or discrimination laws require a certain number of employees before the employee can make a claim against that business. And so once you grow, some of them are 15 employees, some of them are 20. Once you hit that mark, you are open to potential liability under these federal statutes. And so you have to make sure you're, dotting your I's and crossing your T's, making sure you're compliant and, protecting yourself, whether that's something like the ADA. We have clients reach out to us and say, hey, this employee has asked for an accommodation. What do I do? And we'll bring them through the framework. Okay, this is what's required. This is what you need to do. This is how you need to respond to protect them so that they don't get a disability discrimination claim or a failure to accommodate claim. You also need to make sure you're updating your employment agreements. We do draft templates for businesses so that you can update it as you hire for different positions. But we also, as your business is growing, you may be hiring more high up level executive positions. So we may need to take another look at those, revise them, and make sure that any litigation that does happen, we are on top of it. You don't want a default judgment against you for not responding. You want to make sure that you are answering the lawsuit, that you are tendering it to your insurance company if you have that type of insurance. And so we protect businesses in all of those areas. Cool.
Great. Something that we do a lot in our business, and I know a lot of other people do as well. We have a lot of VAs, virtual staff, virtual staff, not necessarily virtual assistant, virtual staff. These are people that are working overseas, that are in other countries. Do you guys do work on that end as well, as far as those kinds of employment agreements go, making sure that everything is up to par and working the right way?
We can look at them. We, want to focus on Louisiana employees. So if you are a remote employee working from here, Louisiana law would apply because this is technically your office. And so we look at those agreements. If it's another jurisdiction, it's a little touchy whether we can look at those. I'm happy to review it. But as far as drafting, it really depends on where they're going to be working and the type of business.
Right. I mean, I'm talking from the employer side of things, as far as when you are hiring virtual staff. Yeah. Is that something that you guys? It sounds like kind of. You guys.
I've drafted some where they have employees in other states, and they're headquartered here, so we can do that. Yeah. Okay.
Cool. Good to know. I'm just curious because I know that's a growing area that people are utilizing more and more. Like I said, we utilize it in our business as well. So, so. Last question here for you, Megan. When you think about your career, what kind of impact do you want to leave on in this space? Like what kind of impact and kind of legacy? And I know you're only 10 years in and you got a whole lot more to do, but when you like, what do you want people to take away from their time spent with you, working on their business?
What a question. We have a new general counsel client this year that I've absolutely loved working with. And one thing she's told me that I just loved is she loves the way my advice makes her feel about her business. She feels a lot safer. And she said, I feel like a grown-up. And I like helping business owners, especially small business owners, feel secure in what they're doing and feel like their business is safe and it's going to succeed. And any way I can help businesses both grow to be more profitable, better, hire more employees if that's what they choose, and feel safe while they're doing it, I love it.
Awesome. Love that. Love hearing that. So, Megan, this has been such a great conversation. I've enjoyed having this talking with you about this stuff and getting into some questions that I had as well. So before we wrap it up here, let people that are we have some people watching live and there are people who be watching after the fact. Let people know, especially if they're a business owner or if they're an employee who's signing a new contract, where they can find you and how they can get in touch with you.
Sure. Again, my name is Megan Kelley. I'm at Business Law Group, and you can give us a call at 504-446-6506 or www.lawgroup.biz.
Awesome. So yeah, if you're starting on a new business, starting on a new partnership, or if you just got hired on and you've got one of those non-competes that you're not sure what it means, call Megan and make sure you get some smarter eyeballs on it than yourself, because I guarantee you she's going to do a better job at looking at that stuff than you will. And that being said, thank you, Megan, so much for coming on. This has been great. Those of you that are watching live out there, we appreciate you guys checking out the podcast. If you're watching the recorded version after the fact, we also appreciate you guys checking that out as well. Make sure you give us a like and a subscribe to the channel. We've got more episodes coming later this week with some more great guests, but for now we're going to sign off. And Megan, thank you again for popping in and chatting with us. This has been a great conversation. I've really enjoyed it, and we'll have to get you back on again soon.
Okay. Thanks for having me.
You got it.
Thanks for joining us on this episode of Partnerships for Profit. We hope you've gained valuable insights on how to form profitable partnerships and take your business to the next level. Be sure to subscribe and leave us a review wherever you listen to podcasts so you never miss an episode. Got a partnership story to share or someone you'd like to see featured on the show? Reach out to us. Until next time, keep building those partnerships for profit.